Hello everyone, I'm Kevin, and today topic is Trump new immigration bill passed U.S. global visa ban policy. Today we are looking at one of the most sweeping changes to America's travel policy in years, a proclamation that now touches 39 countries and puts millions of lives on hold. If you have family overseas, if you are waiting on a visa, or if you simply want to understand how U.S. immigration policy is shifting right now, this video is for you. We are going to break down exactly what changed, who is affected, and what the courts are doing about it. If you are interested in this topic and liking this video, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. In a recent development, the administration expanded its travel restrictions dramatically. What started as a ban covering 19 countries has now grown to cover 39 countries, along with travelers using Palestinian Authority documents. Reports suggest that starting January 1, 2026, roughly 1 out of every 5 countries on Earth was placed under some form of entry restriction into the United States. According to sources familiar with the policy, the restrictions are divided into 2 distinct levels. The first is a full suspension. If a country falls into this category, citizens cannot obtain any visa at all, whether it is a tourist visa, a student visa, or a work visa. Countries currently facing full suspension include Afghanistan, Haiti, Iran, Libya, and Myanmar. For citizens of these nations who do not already hold a valid visa, the path into the United States is essentially closed. The second level is a partial restriction. Nations such as Nigeria, Cuba, Venezuela, and Tanzania fall under this category. People from these countries are blocked from immigrant visas as well as tourist, student, and exchange visitor visas. However, before jumping to conclusions, it is worth noting that some partial restriction countries can still apply for certain employment-based visas, such as the H-1B. So this is not a total lockout for everyone, but it is still a significant barrier for families hoping to reunite, students hoping to study, and workers hoping to build a future in America. What makes this case different from earlier travel restrictions is how it treats close relatives of American citizens. In previous versions of similar policies, spouses and children of U.S. citizens typically received an exemption. This time, that protection was removed for most categories. This means that even spouses and minor children can now be caught up in these restrictions, something immigration attorneys say caught many families completely off guard. So, why is this happening? Officials argue that the restrictions are necessary because of what they describe as screening and vetting deficiencies. In practical terms, the administration says certain countries are not sharing enough security information with the U.S. government, making it difficult to properly vet visa applicants. Supporters of the policy frame this as a matter of national security, arguing that stronger vetting standards help prevent dangerous individuals from entering the country undetected. Despite these justifications, critics see the policy very differently. Advocacy groups warn that the restrictions disproportionately affect Muslim-majority nations, as well as countries across Africa and Southeast Asia, drawing comparisons to the controversial travel ban from 2017. And just as with that earlier policy, this one is already facing serious legal challenges in federal court, with lawsuits arguing that it oversteps presidential authority and unfairly discriminates based on nationality. Let's take a closer look at who is actually affected by all of this. The following categories are currently under the most pressure, starting with new visa applicants from full suspension countries who currently have no path to a U.S. visa of any kind. Next are families from partial restriction countries who face blocked immigrant visa petitions even when a U.S. citizen relative is sponsoring them. Then there are students and exchange visitors from restricted nations, many of whom had already been accepted into American universities before the policy expanded. And finally, there are spouses and children who previously would have qualified for an exemption, but no longer do under the current rules. In addition to these changes, there have been important legal developments worth understanding. In June 2026, a federal court in Rhode Island ruled against part of this policy, stating that United States Citizenship and Immigration Services, or USCIS, could not simply freeze applications from all 39 banned countries without individual case review. That ruling forced USCIS to resume processing certain applications, including work authorization extensions for students, even for people from restricted countries. However, the government immediately appealed that decision, and the legal fight remains ongoing. Then, in late July 2026, another federal judge issued a significant ruling stating that the travel ban cannot be used to block spouses and children of Afghan asylum seekers from joining their families in the United States. The judge pointed out that the original proclamation actually exempts asylees and refugees, yet the State Department continued blocking their relatives regardless. The court ordered travel documents to be issued within 15 days for the families involved in that case. What this translates to is a policy landscape that keeps shifting in small but meaningful ways, even as the broader restrictions remain firmly in place for most people. Beyond the travel ban itself, the administration has introduced other major changes worth knowing about. A new fee for H-1B work visas now reaches as high as $100,000 in some cases, a dramatic increase that is already reshaping how companies approach hiring foreign talent. Green card holders are now facing mandatory biometric screening as part of these broader reforms. Legal analysts describe this as one of the most significant overhauls of American immigration law in decades. There is also a proposed rule that could allow immigration officers to deny green cards to applicants they believe may rely on public benefits in the future, a change that critics argue grants officers far too much discretion. Immigration experts note that the economic debate around these policies is just as divided as the legal one. Some research suggests that combined immigration restrictions could push net immigration close to zero or even negative, potentially slowing labor force growth and consumer spending. On the other hand, other studies show that immigrants, even those without a high school diploma, often make a significant positive financial contribution over their lifetime once taxes and broader economic activity are factored in. In plain English, both sides have real numbers to support very different conclusions, which is part of why this issue remains so contested. As a visa applicant or green card holder, this situation might feel overwhelming, especially with rules that seem to change every few weeks. In practical terms, immigration attorneys are strongly recommending that affected individuals carry proof of their immigration status at all times and think carefully before traveling internationally. Even lawful permanent residents are not entirely insulated from complications. There was a major Supreme Court case this year involving a green card holder who was reclassified at the border because of a pending charge, putting his entire legal status at risk. This case is a clear reminder that border encounters remain unpredictable, even for people who have lived legally in the United States for years. To put this in perspective, the travel ban is active, visa fees are higher, vetting requirements are stricter, and yet the courts continue to push back on specific aspects of the policy, creating small pockets of relief for certain families even as the overall framework stays largely intact. It remains to be seen how future court rulings, possible appeals, and even a potential Supreme Court review could reshape this policy in the months ahead. That's all we have for this bulletin. The Immigration Update channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B-1 and B-2, work visas such as L-1A, L-1B, and H-1B, student visas, green cards, immigrant visas, EB-1, EB-2, EB-3, EB-4, and EB-5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.